Have you ever considered what happens to a nonprofit organization's assets if it ever ceases to exist, whether due to mission accomplishment or unforeseen challenges? It is a question that every responsible nonprofit leader should contemplate, ensuring the organization's legacy is preserved. Nonprofit asset distribution plans are essential legal and operational frameworks that clearly outline how an organization's remaining assets will be dispersed upon its dissolution. This crucial process ensures strict compliance with Internal Revenue Service rules for tax-exempt status, safeguarding the charitable intent behind every donation and effort. The core reason behind these detailed plans lies in the principle of charitable dedication, which is fundamental to a nonprofit's 501(c)(3) status. When an organization dissolves, its assets cannot revert to private individuals or for-profit entities. Instead, they must be transferred to another tax-exempt organization with a similar mission, effectively continuing the charitable purpose for which the assets were originally intended. Developing an effective asset distribution plan involves several key steps. First, the board of directors must formally vote and pass a resolution to dissolve the organization. Following this, a thorough review of the organization's articles of incorporation and bylaws is necessary to understand any existing dissolution clauses. Next, it is imperative to comply with specific state laws regarding nonprofit dissolution, which often involves filing notices with the state attorney general or a similar regulatory body. A critical phase then involves identifying and settling all outstanding liabilities and debts. After all obligations are met, the board must carefully select recipient organizations that also hold 501(c)(3) status and align closely with the dissolving nonprofit's original mission. Finally, the remaining assets are officially transferred, and the organization must file final tax forms with the Internal Revenue Service, such as the final Form 990 and potentially Form 966 for corporate dissolution, formally notifying them of the cessation of operations. A valuable insight for nonprofit founders is to consider including a robust asset distribution clause in the original articles of incorporation. This proactive measure not only streamlines the dissolution process, if it ever becomes necessary, but also provides clarity from the outset. In cases where the specified recipient organization no longer exists or cannot accept the assets, the legal principle of cy-pres, pronounced cy-pres, may allow a court to direct the assets to another organization with a purpose as near as possible to the original intent, ensuring the charitable purpose endures. By diligently planning for asset distribution, nonprofit leaders gain peace of mind, knowing they are fulfilling their fiduciary duties and protecting the organization's legacy. This responsible stewardship ensures that the resources accumulated through generous support will continue to serve a meaningful charitable purpose, even after the original entity concludes its work, reinforcing the enduring impact of collective goodwill.